Welcome everyone who's here in New York with us, and a very warm greeting to everybody who's online. I think we have about 130 people joining us from all points around the globe, and on a Friday evening at that, so we are very impressed with your dedication. We're delighted to welcome you here for today's important event, What's in a Joke? Assessing Humor in Free Speech Jurisprudence and Content Moderation. This gathering is hosted by Columbia Global Freedom of Expression in collaboration with Dr. Alberto Godioli from the University of Groningen in the Netherlands. Over the years, our partnership with Dr. Godioli and his team has flourished, leading to significant contributions in the global case law database and inspiring essential discussions at the intersection of humor and the law. The recent publication of our special collection paper, Humor and Free Speech, a comparative analysis of global case law, stands as a testament to this collaboration. As many of you are aware, humor is far more than entertainment. It's a powerful form of communication that plays a vital role in our democratic societies. Historically, humor has served as a tool to challenge authority, critique societal norms, and regrettably, to perpetuate harm. This duality makes humor both compelling and complex in the context of free speech. In our current digital landscape, where memes, deepfakes, and generative AI complicate our understanding of expression, we face new challenges in navigating the often murky waters of humor. The questions we confront, such as where does satire end and defamation begin? How do we distinguish between a provocative joke and hate speech, are more pressing than ever. And despite the urgent need for clarity, existing legal frameworks often provide inconsistent guidance on these issues. This is precisely where the Toolkit comes into play. It offers a comprehensive set of guidelines for interpreting humor in various legal contexts, including insights on satire, content moderation policies, and the intricacies of intellectual property law. What sets this project apart is its interdisciplinary approach, integrating perspectives from literary studies, sociology, communications, and the law. Our advisory committee similarly brings together humor researchers, lawyers, judges, activists, and free speech scholars, enriching the dialogue surrounding these critical issues. Today, we will kick off with a panel discussion featuring 3 authors of the Toolkit who will share their insights on its various components. Then, after a brief intermission, we will transition to a roundtable discussion featuring esteemed members of our advisory board, including Judge Stella Anukam, Jurist Dr. Barbara Bukovska, Mehdi Benshala, and Judge Darian Pavli. Their collective expertise will provide invaluable perspectives on the relationship between humor and free speech. And I encourage all of you to actively engage in the discussion during the question and answer session. Those who are joining online, please put your questions in the chat and we'll make sure they get to the panelists. So with that, we can get started, and I'll introduce our first panelist. We've got Dr. Alberto Godioli, who is Associate Professor at the University of Groningen, and he's the Principal Investigator of the Humor in Court Project, funded by the Dutch Research Council. In 2022, he co-founded Forum for Humor in the Law, a global platform connecting lawyers, humor scholars, artists, and other key actors interested in humor, freedom of expression, and related matters. Then we have Dr. Sabine Jacques, who specializes in intellectual property law at the School of Law and Social Justice at the University of Liverpool. She serves as an expert analyst for the EU Law Live project, is on the advisory board of the Network for Empirical Legal Studies in IP, and regularly provides updates on humor and IP developments as a member of Forum. Dr. Jennifer Young is a postdoctoral researcher at the University of Groningen, working on humor in the court project. She has co-authored articles with Dr. Godioli on humor in the law and contributed to our special collection paper on humor and free speech. Additionally, she manages the legal database for Forum and is a regular contributor to the platform's blog. So what we're going to do today is each of the authors is going to give a brief presentation on the section that they worked on, and then we will open it up for a question and answer. So I think we're going to start with Alberto.
Sure.
The floor is yours.
Thank you so much. Welcome everyone from my end too. I hope the microphone is okay. You can all hear me loud and clear, but not too loud. First of all, on behalf of the Toolkit team, we would like once again to express our deepest gratitude to Hawley Johnson and the whole Global Freedom of Expression team for having us here and for all their amazing work organizing all this. And special thanks also to the members of our advisory board who are joining us today on site and online as well for all their help and feedback throughout the drafting and now the revision of the toolkit. The toolkit isn't out just yet, but we do have a cover, which you can see there. And most importantly, we have an advanced draft of the text with a view to publishing the final version somewhere in February 2025. So our idea today is really to use this event to collect more feedback and have a conversation around these topics in order to incorporate that feedback as well in the final version. And as Hawley mentioned, what we will do now is we will have four short talks focusing on the key aspects of the toolkit, which we can summarize like this. First of all, what is humor and why it matters? Secondly, interpreting humor in context. Thirdly, humor and intellectual property law. And last but not least, online humor and content moderation. So I will start by summarizing point 1 and some of point 2. Then I will give the floor to Jennifer and Sabine for the remaining parts. The fourth author of our toolkit, unfortunately, could not be here with us today, Ariadna Matamoros Fernandez. So I would also like to take the chance to say hi to Ariadna and acknowledge her great contribution to the toolkit too. Okay, so point 1, what is humor? Very briefly, in the toolkit, we use a very broad definition of humor as a form of what linguists call non-bona fide communication, as opposed to more literal or straightforward modes of expression, which is entirely or partly geared towards amusement and is usually characterized by incongruity. Then what qualifies as incongruity exactly, and the extent to which it might be seen as funny might depend a lot on context, on personal taste, on cultural conventions. So it's really important to stress that there is no objective way to determine what is and what is not humor. Rather, in the toolkit, we try to help courts and other relevant stakeholders address the subjective and context-sensitive nature of humor in a rigorous manner. The same applies to other notions that we use in the toolkit, such as satire, which we define, again, broadly as a form of artistic expression where humor is used to comment on social and political issues, a parody, namely the reuse of existing material or genres, while also shedding new light on them, usually with a humorous spin. So now that we have a few working definitions, I will start with summarizing some of the key takeaways from the first part of the toolkit. I will do that in the form of 3 mottos, so to speak. First motto being humor matters is an easy one, meaning that the freedom to express oneself through humor and satire is a vital part of a healthy society. In the toolkit, we mention some landmark decisions from all over the world stressing the importance of safeguarding humor and satire in particular as part of freedom of expression. For example, the European Court of Human Rights in VBK in Austria famously stated that satire is a form of artistic expression and social commentary which, by its inherent features of exaggeration and distortion of reality, naturally aims to provoke and agitate. Accordingly, any interference with the right of an artist or anyone else to use this means of expression should be examined with particular care. And we can find similar statements in spirit in important cases from all across the globe, really, and we mentioned some of them in the toolkit. And it's interesting to note that most of these passages really stress the importance of protecting satire, specifically in terms of social commentary and contribution to public debate. An interesting variation, though, comes, in our view, from the Supreme Court of Canada, WIC and Simpson, where they state that the law must accommodate commentators such as the satirist or the cartoonist. Their function is not so much to advance public debate as it is to exercise a democratic right to poke fun at those who huff and puff in the public arena. So this is an important point in our view because otherwise distinguishing too rigidly between good humor that advances public debate on the one hand and bad lower-level forms of humor that are seen as more gratuitous might lead to arbitrary or dangerous restrictions and might end up penalizing forms of humor which should not be restricted despite not coming with a clear contribution to public debate. On that note, here comes our second motto, which is humor is also often under threat. In the toolkit, we show how humor is often the first victim of crackdowns from authoritarian governments or in situations of democratic backsliding. And if we look at the types of laws that are most frequently weaponized against humor and satire, we can cluster them into three groups, roughly speaking. We have, first of all, laws that criminalize defamation, insult, or contempt of authorities. And here it's important to stress that there have been widespread calls over the years to decriminalize defamation and insult, so to only address them by means of civil or administrative law. However, many countries worldwide still have criminal defamation laws, which are often used to target satire and humor as well. Secondly, we have vague or misused bans on hate speech, sedition, extremism, and of course, all the examples mentioned there have nothing to do with actual hate speech, but we are really dealing with overly broad, over-restrictive bans. And thirdly, we have outdated or non-human rights compliant laws on religious insult, obscenity, outrage to public morals, and so on and so forth. It's also important to stress that in many of these cases, or in some or many of these cases, the final outcome of the proceedings could actually be favorable to the humorist or satirist. However, this will only happen after years of emotional and financial strain due to the long proceedings. So in those cases, the waiting is also the punishment, as we were saying, which also comes with a strong chilling effect on humor and satire. Now, the main defense that we have against these threats lies in international human rights law and standards, starting with the so-called three-part test mandated by Article 19 of the International Covenant on Civil and Political Rights, ICCPR, whereby for a speech restriction to be legitimate, the restriction must be provided for by law, must pursue a legitimate aim, and it must be strictly necessary and proportionate to pursuing those goals, those aims. The aims, as per the ICCPR, include and are limited to the protection of the reputation and the rights of others, national security, public order, health and morals, or as per Article 20, prohibiting incitement to discrimination, hostility, or violence. Now, when assessing the necessity of a given restriction of speech, humor should be subject to the same criteria as any other type of expression, really. So in reputation cases, there is the idea that public figures should display a higher tolerance of criticism, ridicule. In incitement cases, we have the guidelines coming from the UN's Rabat Plan of Action, so the importance of looking at the context of the expression, status of the speaker, intent, content, the extent of circulation, and the likelihood of harm, and so on. That being said, even within, let's say, human rights compliant judicial systems, there are some recurring challenges in humor-related case law that really have to do with the inherent features of humor. So the fact that humor by nature is a form of non-literal expression based on the exaggeration and distortion of reality, the fact that humorous intent is usually not spelled out in any explicit way, and therefore the fact that humor is highly reliant on context and conventions. So these features might cause a series of problems when assessing the necessity and the proportionality of a given restriction of speech or artistic expression and so on. For example, when drawing a line between satirical exaggeration on the one hand and a defamatory claim on the other, a parody of racism and actual incitement to racial discrimination, or a dark disaster joke, for example, and actual advocacy of terrorism, and so on and so forth. So this is specifically where the toolkit tries to help by means of offering insights coming from scholarship about humor, from the humanities and the social sciences, in ways that could come in handy when addressing these type of issues. A good part of these insights can be summarized with our third motto, and I'm almost done with my bit, the third motto being context matters, especially so in humor cases. But then again, what do we mean by context? So in the toolkit, we try to tease out the main things that context can mean in a humor-related case, including the communication setting, so the circumstances in which a joke was uttered or circulated, power relations between the humorist, the target, the audience, the context, so the information surrounding the joke that might help with the interpretation of the joke, then intertextuality, meaning simply the references or allusions to previous works, previous texts on the part of the jokester, and lastly, the genre or the tradition that the joke can be ascribed to. I only have time for one example of why context matters in humor-related cases, and so I just pick one from the European Court of Human Rights, which is Sinkova and Ukraine, concerning the detention and conviction of Hanna Sinkova, an activist who had fried eggs on the eternal flame of the tomb of the unknown soldier in Kiev in 2010. Sinkova later posted the video together with her activist group online, claiming that this was meant as a protest against the waste of natural gas. So Sinkova was eventually received a 3-year suspended prison sentence in Ukraine. Then the case went to the European Court of Human Rights, which upheld the sentence with a tight majority of 4 judges to 3. In our view, the context here was neglected in 2 ways. First of all, the majority of the European court there did not take issue with the fact that the Ukrainian courts did not really consider the co-text, so the statement that was issued by Sinkova and her group alongside the video, clearly stating that this was a protest against the waste of natural gas. And also, it's important to say, I forgot to mention that Sinkova, the prison sentence was due to desecrating a burial place. That was the issue at stake here. Secondly, as to genre, the protest could and maybe should be seen as part of a growing genre of, let's say, political activism that combines absurdist humor with performance art. This genre is referred to as a humorous political stance in this book by Micah Sørensen, or it's also known more recently as laughtivism. And strikingly, the European Court's majority did not really mention humor or satire in the judgment, but rather added that there were many suitable opportunities for Sinkova to express her views without insulting the memory of soldiers, which in a way neglects the fact that laughtivism makes a strategic use of provocation in order to raise the awareness, let's say go viral, especially online, and raise the awareness around a given issue. So in light of both the co-text and genre here, it seems clear that the protest was really not about insulting the memory of the soldiers, but rather to spark a debate around a different matter. But this is just an example of why a thorough assessment of context could matter in a humor-related case. And I will leave it at that for now, and I will give the floor to Jennifer, who will elaborate on another important contextual aspect, which is the audience.
Thank you. So in the draft, we discussed some case examples in which the court constructed a reasonable reader, or in some cases an unreasonable reader as the audience, rather than solely focusing on the objective or subjective intention of the speaker. And I'll run through 3 of these to illustrate some of our points. In Nickowitz and Verlagersgruppe News in Austria, it introduced the criterion of the average reader to the European Court of Human Rights. A magazine had published a satirical piece which included an Austrian skier celebrating his sporting rivals, breaking his leg, as the accident meant that he could finally win something himself. And he successfully sued for defamation in the domestic courts, and the news group took the case to the European Court of Human Rights, with the Austrian government arguing that the average reader wouldn't grasp that the passage was satirical. And the European Court considered the article in context, concluding that it was humorous commentary, and this was clear from its headings and the photographs' captions. And I've skipped ahead too far, forgive me. The captions and the text's ironic and satirical style. So the court wasn't convinced that the average reader wouldn't get the humorous nature of the article. And the court concluded that the restriction wasn't necessary. It was a violation of Article 10 of the Convention, which is the freedom of expression. And the judgment criticised the Austrian court's reference to the standard of unfocused, hasty readers who might not get the joke, and that they would restrict the right of freedom of expression because of ignorant readers rather than the average reader. So this case illustrates how, by evaluating the communication setting, the court established that the average reader would get the joke, and it was written by a satirist. It was published in a magazine known for satirical commentary, and the ironic and satirical style was important to as part of the judgment, that the average reader would understand it was satirical. But of course, when it comes to online, it's much more difficult to establish who the average or reasonable reader is. It might appear in a feed that's context-free, especially when coded language or humour creates a grey area around intent and meaning. And this is a recent report by the European Commission, which highlighted how the far right is increasingly using humour as a front to spread and normalise hate speech. In a recent Belgian case, Schild and Vrienden, concerned with a far-right political group who had posted racist and anti-Semitic memes online, the court had noted how humour was used to make racism accessible and light-hearted. So an early case example of this is Ferré in Belgium. Ferré was the former president of the Front National, and his party created cartoons, caricatures playing on racist stereotypes with xenophobic slogans and jokes. And these mainly targeted Muslims. He was charged by the Belgian courts for inciting discrimination, hatred, or violence on the basis of alleged race, national or ethnic origin, and banned from political office for 10 years with a suspended prison sentence. He took his case to the European Court, who found no breach of his Article 10 rights. And part of the court's reasoning was that they considered not only the reasonable reader's interpretation of these jokes, but also the irrational response they were likely to trigger among people more prone to xenophobia. So while the case predates the publication of this, the Rabat Plan of Action, we see a number of the threshold tests are considered. And the Rabat six-part threshold test is a practical tool to combat incitement to hatred and forms of speech prohibited under criminal law. And the test has been used by bodies including national authorities for audiovisual communications, the European Court of Human Rights, and also the Meta Oversight Board. It's useful in judging hate speech acts, as its test aims for a multidimensional contextualization of messages necessary to understand and to assess covert hate speech. And the threshold of intent requires the activation of a triangular relationship between the object and the subject of the speech, as well as the audience. So this reflects the complexity of speech reception and the importance of evaluating the communication setting and taking into account who the audience is, or as we refer to, as presumed addressee. So using a threshold test similar to Rabat, combined with an evaluation of the communication setting and contextual features as set out in the draft toolkit, we think could create a more consistent approach to assessing the legal limits of humour. And this is reflected in my final case from Canada, where the courts consider the reasonable public aspect of the audience. In the case of Ward in Quebec, the comedian Mike Ward, you can see here, mocked the young singer Jeremy Gabriel, who suffers from Treacher-Collins syndrome. And this can cause facial deformities and, as in Mr. Gabriel's case, deafness. And Ward exaggerated Gabriel's voice and appearance, describing him as having a loudspeaker on his head and a mouth that didn't close all the way. He joked about trying to drown him and branded him as unkillable. And in ending his routine, he said that he discovered from searches that Mr. Gabriel's illness was being ugly. And the Quebec Human Rights Tribunal found that Mr. Ward had infringed Mr. Gabriel's right to dignity on the basis of his disability. And the tribunal also found that Ward's comments exceeded the limits of what a reasonable person can tolerate as freedom of expression. Ward's appeal was dismissed, but then he appealed to the Supreme Court of Canada, who found that the tribunal didn't have a jurisdiction, as it shouldn't have considered the discrimination complaint. The majority judgment, and it was a narrow margin of 5-4, considered that the reason Mr. Gabriel was the target of Ward's jokes was because of his fame and not because of his disability. Whilst, on the other hand, the dissenting opinion believed that the central question was whether the impairment of the equal right to dignity was sufficiently serious or justified by the comedian's freedom of expression. So Mr. Ward's jokes about Jeremy Gabriel were self-evidently pejorative slurs based on his disability. He referred to Jeremy Gabriel as the ugly singing kid. His jokes about drowning Mr. Gabriel drew on harmful stereotypes about people with disabilities as being disposable. And in regards to power relations, this was a famous comedian punching down on a child with disabilities because he was very young at the time, rather than the majority view of punching up at a media celebrity. So the dissenting opinion believed this should have been considered as a factor in deciding whether Mr. Ward's comments were likely to cause serious harm to a reasonable person in his circumstances, as in Jeremy Gabriel's circumstances. And they noted that the court had consistently recognised how certain forms of discriminatory speech may cause serious individual and societal harms which justify limits on expressive freedoms, stating that the dignity of public figures isn't necessarily subservient to the right to freedom, to the right to express harmful remarks. And of course, this would have had a chilling effect on Jeremy Gabriel as well. So, as pointed out in the dissent, the majority's reasonableness criterion overlooked relevant contextual information, including Jeremy's age, his social circle, and it should have judged the impact on a reasonable person in Jeremy Gabriel's shoes, who would be particularly susceptible to the harms associated with dehumanizing comments. And so here the dissenting judges have made the argument that some of these contextual features which we've mentioned in the draft and the specific communication setting and the power relations should have been considered more closely in the decision. And on that, I will hand over to Sabine.
Thank you. Thank you, Jennifer. Here we go. So we're going to move to a different angle on this topic, which is humor and intellectual property law. And I would like to start with this example. So in 2023, we have a video by Greenpeace that shook the Rugby World Cup. The video, titled "Total Pollution, a Dirty Game," portrayed a striking image. We have the Stade de France symbolically flooded with oil as a statement against Total Energy's sponsorship of the Rugby World Cup. The message was clear. The campaigners were calling out the energy giant for its role in climate destruction and questioning the ethics behind its sponsorship of such a prestigious global event. So, following the Greenpeace received some cease and desist letter from representatives from the Rugby World Cup Limited for addressing this unauthorized use of trademarks of the partners. Greenpeace responded to this letter, and another letter then arrived, this time from the right holders of the stadium itself for copyright infringement. So I think this example is quite telling because it shows how now increasingly we see that these type of uses are creating tensions within an IP context, where we have issues in terms of the relationship between the right to freedom of expression and property rights for the IP owners. This is even more problematic because now the scope of these intellectual property rights have expanded quite significantly, and that the accumulation of intellectual property rights over some expression has been endorsed by courts. So if we don't have a legal framework that preserves this type of humorous uses, we can also use intellectual property law in a strategic way to censor expression as well. So when we're talking about humoristic uses, we encounter a number of difficulties, and here I'm talking about the perspective of intellectual property law. We see that these terms are frequently employed, so parody, pastiche, caricature, satire, burlesque, but they're notoriously difficult to define or to grapple. So it's not really surprising that courts also struggle with distinguishing lawful humorous uses from violations or harm done under a joke-type defense. Intellectual property law is definitely there to protect creativity. And initially in this intellectual property framework, we see that humorous uses of existing literary works has a very long history. However, now the practice is much more widespread in contemporary culture, where we have a broader range of IP materials that are used for these humorous uses: songs, photos, logos, product appearances, works of architecture, and now applied art. And more we see that we have humorous uses not only of creative expression, so copyright, but is entering more and more the industrial realm as well. These can also serve a variety of different purposes, whether it's from provoking laughter, criticism, providing a social or political commentary, paying homage, or exploring artistic conventions. So the question is, where do we draw the line? What's acceptable and what isn't? So in terms of IP basics, intellectual property law is there to protect creativity, and historically that has meant that there is a high level of protection for right holders of these creative expressions. Humorous uses of IP materials therefore often result in an infringement of these rights, unless obviously you've been able to secure a license, so prior authorization for the use that you're about to make, or unless there is an exception that is applicable. Now, if we look at the international legal framework, so IP treaties, we see that these exceptions for humorous uses needs to satisfy a three-step test. So that means that these exceptions and limitations must be confined to certain special cases, that they do not conflict with the normal exploitation of the IP-protected materials, and they do not unreasonably prejudice the legitimate interest of the right holder. Beyond this, it's very much a matter for regional or domestic law. So that leads to my next point, that is that currently we're dealing with a very fragmented approach and inconsistent legal frameworks in order to preserve this type of humorous IP uses. What do I mean by this? Well, if we look at copyright, that's typically the most permissive IP right when it comes to these humorous uses. There's no harmonization, so it very much varies from a country to country. Typically, these uses are either accommodated through fair use, fair dealing, or a specific type of exception. So either we have an open norm or a more specific exception with requirements to meet. But some countries like Finland, Italy, or Hong Kong do not have a specific parody exception. And some of these countries then will allow these humor-based uses by referring to constitutional principles. So a key challenge here is that we have already a lack of consistency in terms of approach, and that has an impact on the assessment of these uses and the scope. There's also differences in regarding the purposes themselves. So some countries will allow parodies, so where you reproduce somebody's IP materials in order to make a comment on these materials, or whether you allow also to use these IP protected material as a vehicle to comment on something totally different, so a satire. So there are issues regarding the purpose, regarding the form of the exception. There is built-in flexibility where when we have a country that has more of an open norm approach. So, for example, a fair dealing would be a good one because the courts are able to develop factors as they have to deal with cases. There are some countries that have specific exceptions, but with built-in or openness as well. That would be the case, for example, for France, with the rules of the genre. And there are also additional provisions when we're dealing with digital uses. So, for example, in the EU, the most recent copyright directive has Article 17, which is a very complex legal provision, but that basically says, well, where the large online platforms have to adopt these kind of filters, they still have to make sure that parody, pastiche, and caricature can flourish. Now, to what extent this is doable in practice, obviously, remains a question. But there is this commitment that these are expressions that we ought to preserve. Now, there are also additional new challenges, obviously, in the context of generative AI, deepfakes, and how we actually balance the human rights in conflict in regards to these new uses. Trademark law is a bit more complex. In the sense that, so here we're entering the industrial property realm, so much more focus on the economic perspective of the uses. So here we can think of two possible harms when we're talking about humorous uses. Either, let's say, the trademark parody, so you parody a logo, could actually lead to some type of consumer confusion, or you're actually creating harm to the uniqueness of a well-known mark. So the brand. There is some kind of built-in safeguard in trademark laws around the world. This is, again, there are exceptions. So, for example, it has to be a use in the course of trade. So, if we're dealing with a use that is not in a use of in the course of trade, in theory, that should be allowed. The exception being the Benelux, or use as a trademark, so linked to some goods and services. So there is no exception for humorous uses there, apart from in the US, where we do have a more specific exception, but in the EU we do not have one. But there are ways to kind of save your use if you can show that it's not within a commercial setting or linked or used as a trademark, or by raising a due cause defense. In designs, well, interestingly, there has been no exceptions to date, so no specific defense. But this is changing because the EU is also paving the way here by introducing a new exception for parody use in its recast design directive. But interestingly, it's subjecting the exception to fair trade practices, which might not be well suited for the types of use that we have in mind. So that's about the legal framework, very fragmented. In the toolkit, we try to give more of a feel about the different systems that you can find, but that leads to a lot of legal uncertainty when it comes to court's decision as well, because there's a lot of inconsistencies in the court's reasoning and the outcome within similar facts. So here in copyright, so as I said, there's generally built-in flexibility, and if we look at the types of factors that courts will tend to focus on, they will generally look at the intent of the user, the absence of confusion. So by looking at a parody, are you able to see that it's actually not coming from the right holder? The amount reproduced in some jurisdiction is quite important. So if it's a wholesale copying, that will generally tilt the balance against the finding of a legitimate use and the motives of the parodies. Some jurisdiction will also adopt additional factors, such as looking at the impact on the economic rights of the right holders, whether there were alternatives to the reproduction made, as well as applying this three-step test that I was mentioning to particular facts. And especially in an EU context, there's also this requirement that courts balance the fundamental rights in conflicts, especially looking at the property rights of the right holders versus the user's rights. In trademark, because the situation is much more complex, the reasonings are much more complex as well, but there are some very interesting developments, especially coming from France, when we're dealing with non-profit organizations that are acting in accordance to their social purpose. Here we see that there has been tests that have been developed by the courts in order to facilitate this type of uses. And this interesting category of speech is when the trademark parody is done in a political context, where we see here that there are big differences between countries. Artistic, when a logo is being parodied for an artistic purpose, generally this will be rendered as legitimate. However, as soon as we're dealing with uses that are between commercial undertakings in relation to, operating in separate markets or between competitors, we see that courts are drawing a line as to what is acceptable. For designs, while we know very little, we have no idea on how this new exception will be operating. So far, and that was the case in the Simply Living case, we had recourse to freedom of expression principles, so as an external mechanism in order to resolve the conflict at hand. But we might see new factors arising, given that now there will be a statutory exception for humorous uses in designs. So some of the, and that's something I wanted to end with, some of the toolkit recommendation of how to assess these humorous uses when we're talking about IP protected materials is to first look at the use as a whole. So if we go back to the example in the introduction with the Greenpeace video, I don't think it is really necessary or productive to actually look at the application of the exception with every single reproduction. So for example, has there been a parody of a building in that case? I think we have to make an assessment of the expression as a whole. We also have to think about how perhaps of recognizing parody as an umbrella term that will also cover other related genres that are difficult to distinguish in reality. And often these other related genres will also be at play in a single use. So, for example, there's no need from an IP perspective to distinguish a caricature from a parody, because often a parodic use will also include elements that could be considered as caricature. We see that with a lot of the cartoon parodies, for example. if we are to make a strong commitment to freedom of expression, we have to recognize the legality also of parody of and parody with. So that's like parody in a narrow sense versus satire, as requiring the same level of protection, and that's not always the case in national case law. The next one is coming from a European dimension, but in the Degmin case, which was decided by the Court of Justice of the European Union, we see that the humor or mockery is a requirement for the parody exception to be applicable, but I think we can do better in understanding the scope of humor. So firstly, and I think this is accepted, that we should look at the intent of the speaker, but also perhaps we don't have to adopt a narrow definition of what is humor to preserve more forms of humor. So perhaps having a negative definition is helpful. When it comes to commercial exploitation of the expression, we have to ensure that this should be allowed, but perhaps we have to be more tailored in our assessment to actually have a look at what is being commercially exploited. Are we trying to commercially exploit the IP materials that have been reproduced, or the expression that is made by the speaker? I'm going to quickly wrap up. The next one is that because one of the elements of these uses is to understand that we're not in presence of the original. I don't think we need to be able to identify who the speaker is in every single situation. Being able to just identify that we're not in the presence of the original material should suffice. So there's no need to credit the original source, although if that can help you to distantiate and to avoid any confusion in the public's mind, that can be an element of being used. So as you can see, there's a series of Toolkit recommendations that we would really be happy to hear your feedback on once it's being published. I'm going to hand back over to Jennifer.
Alberto.
To Alberto.
I think it's Jennifer, actually.
It's okay.
Yeah, this would have been Ariadna's part,
Yes.
but unfortunately
And
she's not here
Ariadna's
with
not
us,
here.
so we'll take over.
Okay. So I'm going to talk about online platforms and human rights. Online platforms are private businesses, and because of this, they're under no obligation to protect freedom of expression. Platform users' posts need to comply with both the applicable law and any additional policies, community standards, or terms of use which the platforms impose. If not, posts can be removed and users' accounts could be closed. So to counter the potential implications of this to freedom of expression and other human rights, the UN published its guiding principles for business. And this established a voluntary framework for the human rights responsibility of private businesses. And UNESCO has also published guidelines for the governance of digital platforms with the aim of safeguarding freedom of expression. And although most of the very large digital platforms are US-based, they also have to adapt to more restrictive regulation because of their international reach. And very large online platforms have specific requirements to meet under the EU's Digital Services Act. And this addresses issues such as disinformation, risks to electoral processes, illegal content, and negative effects to human dignity and other fundamental rights, including freedom of expression. So there's a gap at the moment in platform policies with regard to the moderation of humorous expression. Of all the very large platforms, that's Facebook, Twitter, YouTube, and TikTok, Facebook has the most comprehensive guidelines regarding humor. Most platforms don't provide clear definitions for humor in its various forms and genres, and this adds to the interpretive challenges posed by different cases. And this feeds into problems for the human moderators, and that's leaving aside the automated content moderation as well, because the possible multiple interpretations of humor, such as the difference between disinformation or fake news or satire about news events, hate speech and ironic hate speech. So this is exemplified by the first Meta Oversight Board case involving satire, and the board's decision is binding unless it would violate applicable law. And they only select a handful of cases which they think will have a policy implication from the millions that are raised. In this meme, this is the daily struggle, or the two buttons, the character was trying to decide which one of the two buttons to push. The one marked the Armenian genocide as a lie, or the other, the Armenians were terrorists that deserved it. And this was flagged by a user and removed as it was interpreted as celebrating or trivializing the Armenian genocide. The user appealed, stating that the meme was not meant to offend, but rather to show the irony of these conflicting statements. So the majority of the board considered this. Oh, that's yours, isn't it? Sorry.
I think this is the one, right? Don't worry. Spoiler.
Yeah, I'll go back. The majority of the board considered this meme was covered by Meta's satire exception within the hate speech community standard. They thought the user's intent was clear, condemning hatred and raising awareness about successive Turkish governments' refusal to acknowledge the Armenian genocide, while simultaneously trying to justify the atrocity. And for the minority of the board, this intention was not clear. They believed that the users might be sharing the content to embrace the statement rather than to refute it. And so it violated the hate speech community standard, and the user's intent should have been made explicit. The board's analysis was informed by various human rights standards, including the Rabat Plan of Action, which I previously mentioned, and they overturned the decision to remove the meme, finding that it was political commentary. So in this case, both context and genre indicate that the meme is not a celebration of the Armenian genocide. Those who are aware of the genre of the meme understand that the pusher of the button is the target of the joke. And regarding the context, the page where the meme was posted wasn't about spreading anti-Armenian hate. Taking this into consideration, the majority of the board was right to conclude that rather than celebrating or denying the Armenian genocide, it was targeting Turkey's stance. And in a non-binding policy advisory statement, the board recommended that Meta put adequate procedures in place to assess satirical content and relevant context properly, where users share hateful content, to condemn it or to raise awareness. And Meta since incorporated the satire exception publicly into both hate speech and dangerous organisations and individuals' community standards. But more recent oversight board cases show that Facebook still has difficulty with interpreting satire, and Alberto will expand on that now.
Thank you. I will expand, but very briefly. Just to say that, yeah, as Jennifer mentioned, Meta adopted a satire exception after the two buttons meme case, but clearly there are still some ongoing problems with the handling of humor and satire, as shown by these 5 more recent cases where the Oversight Board concluded that Meta had either incorrectly removed content that actually qualified as a lawful satirical criticism, that's the left side of the slide, or to your left, or left up by mistake instances of dark humor that were actually violating Meta's own hate speech policies. For timing reasons, I won't go into detail with any of these cases. I just wanted to say that in the latter group, left up by mistake, the mistakes are the result of human review, while in the former group, it's a mix of automated content moderation and human review gone wrong, let's say. In order to briefly comment on these cases, we'll just briefly go back to something that we write about earlier on in the toolkit, so this spectrum-like taxonomy of different types of dark humor. On the one hand, you have what we call disparaging dark humor, very simply, so where the aim is to mock the victim of the dark event or scenario evoked by the joke. Example, racist jokes trivializing or condoning racial violence. And this form of dark humor may well qualify as incitement to discrimination, hostility, or violence, or otherwise cause some sort of cumulative harm by adding to a hostile environment towards a given vulnerable group. On the other side of the spectrum, we have the opposite of that, so sarcastic dark humor, which aims to denounce the perpetrator in a given dark situation, scenario, by means of irony or sarcasm. Example, jokes that echo racist tropes as a way to satirize them, which might be a risky strategy, of course, but can also be an effective tool for social commentary. And somewhere in between, we have what we call taboo-breaking dark humor, which aims to make light of dark taboo subjects just for fun, so to speak. example of that, the growing plethora of 9/11 jokes or memes shared online by Gen Z users, some Gen Z users, which might well be tasteless, but is also in principle a lawful form of expression as well. So, in a nutshell, if we look at the oversight board decisions, we can see that Meta still has some problems in terms of overlooking disparaging examples of dark humor due to their coded nature. On the other hand, sarcastic dark humor tends to be mistaken for actual disparagement. And then taboo-breaking dark humor is also often at risk of incorrect removal. We would need more data there, but it's quite likely that this third category is well represented in the vast amount of appeals that reach the oversight board. What we do know is that these problems with humor have wide-reaching consequences. Of the 7 million and counting appeals that have reached the oversight board so far, in approximately 30% of the cases, the user states it was a joke. So clearly reaching a fairer assessment of humor in bulk is of key importance for Meta, but also for other large online platforms. There is clearly no silver bullet there which is going to solve these problems. Two things that we stress in the toolkit. First of all, the need for more humor-specific training for data trainers and for human reviewers. Hopefully the toolkit can be a useful step in this direction as well. And secondly, when it comes to disparaging humor in particular, we stress the importance of a diversified approach involving a broad range of stakeholders and methods. So going beyond mere content removal and also engaging in counter-speech, building media literacy and humor literacy, and so on, which is also in line with the UNESCO guidelines for a multi-stakeholders approach to the governance of digital platforms. Okay, I'll stop it here. Thank you very much for listening, and I hope we still have a few minutes for discussion.
Great. Thank you so much, guys. That's an incredibly helpful overview of all the different sections. So I thought we'd start off with a sort of a broad-ranging question that touches on everything that you guys have talked about from the different areas. And so from your individual perspectives, how does the notion of context change from offline to online humor? So who would like to start with that?
Shall I start and then we go?
We can
down the line.
Can't we?
Yeah. I would just mention one thing, maybe, which is the notion of genre, again, which, as you know, I'm a bit obsessed with, but it's also part of context, and clearly there are new genres of online humor that are typical of the online environment, and those also have an impact on the assessment and interpretation of humor. An example of that being meme templates. We had Jennifer discussing the two-button meme case from the Meta Oversight Board, and in that case, the template of the meme and the way in which meaning is construed within that template is important to keep that in mind when assessing content. And that's just one example, but we also have some actual court cases that we discuss in the toolkit that have to do with memes, and in those cases too, there is clearly, like, these cases also show the importance of interpreting those memes in context, not only the context in which they circulate, but also the context of memes as a genre, as a form of communication. So that's one thing that we could add.
But of course, when you've got it online, you don't know who your target audience, you don't know who the audience is, because you don't really have a target audience. It basically just goes out to everybody. So in that case, if you don't understand the genre of the meme, it becomes more problematic when you're trying to interpret it. Yeah. Which is why it's, without knowing what it means, you can't necessarily understand who the target of the joke is. You can't necessarily understand that it's the guy pushing a button. You look like it's just two really disparaging comments. Yeah. So it's harder to judge, definitely.
And there are some types of online humor that really thrive in this sort of ambiguity. You know, like we touch upon the case of the Nazi dog case from Scotland. This YouTuber, Mark Meacham, who posted this video online of himself training his girlfriend's dog to do like the Nazi salute, and he added a short disclaimer at the start of the video, which kind of clarified or stated that he was not endorsing any form of Nazi or neo-Nazi ideology, but clearly there is also a strategic use of ambiguity there in order to be edgy and go viral. And this is also part of this kind of gray area that we try to tackle in the toolkit. Yeah. You know, Sabine, if you have any...
Yeah, I mean, I agree. Firstly, with everything that my colleagues have just said, I think, like from an IP perspective, the thing that I could add, and here this is perhaps very specific to the EU, is that originally, so the Information Society Directive that facilitates the introduction of a parody exception in EU member states is not mandatory. So, you know, countries can decide to introduce it or not. Now, what's interesting is that in the latest copyright directive, the DSMD of 2019, we see that this is a mandatory requirement to preserve parody, pastiche, and caricature online. So, firstly, there's this problem that perhaps the analog world then becomes less accommodating of parodic uses versus the online environment. But then we have to also remember that in the Copyright Directive of 2019, these obligations are on very large platforms. So we might have also double speed freedom of expression between smaller platforms that do not have to comply with this new obligation and the very large platforms. So it's very difficult.
Thank you for that. We have an online question. So I will read it off here. Can platforms be confident that they are making the right decisions on content moderation when the courts face the same uncertainties? Is content moderation in relation to humor compatible with the business model and reality of platforms? Is it not too restrictive? Wouldn't it be better to ensure an in dubio pro libertate approach to content moderation? In case of doubt, the platform could choose to maintain the item and leave the controversy to the courts without being liable for failing to fulfill its due diligence obligations. Then the controversy would be between individuals. Who would like to take that on?
Thank you. That's a great question. And
very detailed.
It's also a pity that Ariadna is not here because she's also the one that has engaged the most with problems related to like the regulation of online speech on the part of platforms in particular.
But I think there's various reasons as well why platforms do regulate more strictly, is because they want to protect their brand, they want to protect their users. So it's not just a case of freedom. Well, I mean, it depends on which platform. Of course, we have very different attitudes across platforms to regulation, but a lot of the platforms want their users to have a nice experience, shall we say. So they want to protect the users, they want to protect their brand, so therefore they're more likely, I would say, to err on the side of
caution.
Yeah, caution than they would do otherwise.
So it's not only like a regulatory need, but also in terms of brand protection.
Yes, exactly.
Yeah, I think there's also like the feasibility of all this, right? There's just so many expressions out there. So they will rely on filters, and we know that, you know, filters, algorithm cannot really appreciate the context of a joke either. So I would definitely I would rather see that we actually err on the side of caution by actually protecting the expression rather than perhaps removing it or making it unavailable or on platforms, and then hoping that the users will be able to bring it to court, which seems to be what the EU is trying to do, at least in the context of Article 17 of the DSMD, and it remains a defense. So how likely this is actually going to be helpful is a big question.
Well, thank you. Oh, we have a question from the audience. This is wonderful. Does somebody? We can get you a microphone. That'll be easier. That way, people online.
think it's
Humor or mockery is essential and should focus on the intent of the speaker rather than its effect.
yeah.
And you know how you were talking about earlier how people can just say, they'll say things and then, oh, it's just a joke.
Yeah.
And so that falls into that category because then you're looking at assuming what someone's intent can be. And that becomes also very, very difficult. So I'm wondering how this is being used as a tool
Mm-hmm.
for recommendation when it's something that cannot be, really assessed.
Well, there is first the problem of having, basing this on the humorous character on the effect, right? Because this is sometimes outside the hands of the speaker. You never know how, the joke will land. So by looking at the true intent in an objective manner, some courts are, obviously this is a question of facts, where they will actually look at what's happening. It's to decipher exactly whether it was for a humorous purpose or whether the intention was to create harm. So this seems to actually work quite well in number of courts' decision, and it does mean that the more you can kind of, in terms, again, this is for IP, right? So the more you can have evidence in terms of your creative process and what you were trying to achieve in an objective manner, the more it will be useful for the course to actually objectively trying to understand what was your true intent behind the use. Again, going back to an example like the one in the introduction with the total pollution, the intent of Greenpeace is really to raise awareness about greenwashing in that case. I agree with you, in some cases it might be more difficult, but then perhaps the defense will not be available in that case. Yeah.
And then there was a slide that was after the interpretive, I don't remember exactly what it said, but it was actually before.
Before.
No, sorry, not before the lead slide, but after.
After.
The title of it was Interpretive.
Challenges.
And people online, I think, are having a hard time hearing the question.
Oh, okay.
I can talk to you after.
Okay.
Test. You've got to talk into the mic. You have to hold it up to your mouth.
So, are there any other questions in the audience? Well, we're out of time. Do you want to take any more questions, prepared questions, or would you like?
That's okay with everybody. We can also take one more question and then have a break. But I'm also aware that that's how I feel.
Okay, we'll do one more. So Forum recently published a blog about two interesting cases from Belgium. In one of them, it's the case of Schild and Vrienden. The Belgian First Instance Court convicted a member of parliament for various violations of the anti-racism and Holocaust denial laws after he shared racist memes on a far-right activist youth movement's social media pages. The blog observes the decision was an example of the European judiciary looking for an appropriate response to right-wing populism. Could you tell us a little bit about the context of the case and whether you think the court struck the right balance?
Jennifer, would you like to start? Shall I?
Well, the case originated because there was a documentary, as I understand, about the political party. Mm-hmm. And I think the idea was it was supposed to expose the political party, the right-wing political party, and shed a negative light over it. And what actually happened was it ended up giving it more exposure and making it more popular. So it kind of backfired in that way.
Exactly. That's a very important background fact, absolutely. And yeah, the main things I can think of right now, and I am actually relying on a great analysis of the case written by our forum collaborator Babette Denayer. So if you're interested in finding out more, you can also visit the forum website. But I think there are many things that could be said with regard to the necessity and proportionality test. In this case, one, thing that it's important to stress perhaps is that the court, the first instance court there, did not focus or place all the emphasis specifically on the content of each and every meme, but rather on the systematic use of those memes in order to create a climate of hostility and discrimination within those online community of this far-right group. So that's an important aspect to keep in mind when you talk about the cumulative harm that can be like created by certain types of disparaging humor, especially when used strategically on the part of political actors, let's say.
It was a real drive to kind of normalize the speech,
Yeah.
to make racist and xenophobic speech kind of acceptable, shall we say, and by using comedy to do that, it makes it much more accessible.
Yeah. Then, of course, we could continue like discussing the proportionality issue of the conviction, but it's also interesting to mention the appeal court is now reviewing the case, so that might actually change in the second round. But we'll leave it at that for the time being on a cliffhanger. But, yeah.
Okay.
Yeah.
Do you want to take any?
I don't know, because I'm also mindful of time, and
yep.
I know like we might all need a coffee break, so I don't.
Okay.
I mean, I could go on a few hours.
Well, thank you very, very much. This has been an awesome panel. We've learned so much.
Thank you.
Take
Thank
care.
you. Thanks for coming.